us, and thank you all for attending. I hope you find the material helpful and that we'll be able to address any questions you have. Any questions can be either typed in the chat box, or you can raise your hand and Lisa can call on you, or just unmute yourself and call out. We're all friends here. So this pandemic has caused a sudden shift in lifestyle for the vast majority of us, especially those of us with small businesses. When I was talking to Lisa about doing a trademark application workshop, she said, you know, when there's an old adage that when fishermen cannot go to sea, they mend their nets. And that really resonated with me, because now's a great time to address those tasks that we never managed to get around to while we were at our former daily grind. So now that everyone sort of shifted out of what used to be our lifestyle, now's might be a good time to address things like trademarks. The purpose of this presentation is a step-by-step tutorial for filing a federal trademark application. Why trademarks? Well, it's relatively easy to DIY, and the stakes are relatively low if you make a mistake. So if you're going to try to DIY any kind of intellectual property, trademark is actually not a bad way to go. Okay, about me. My name's Phyllis Simon, and I have a solo law practice, Simon Law PLLC. I started my solo law practice last summer after over a decade of working in small intellectual property boutique law firms. The mission of my practice is to help small businesses understand trademarks, copyrights, and patents. And now the standard disclaimer, you can literally see the fine print there. This presentation is for informational purposes only. Nothing in this presentation should be interpreted as legal advice. This presentation is intended to help a person to understand trademark, the trademark application, to help ask the right questions with the attorney of their choice. Your time to act may be very limited, and this could substantially reduce your rights and options. You cannot rely on anything contained herein. And this information is not intended to substitute for professional legal advice and does not create an attorney-client relationship. You should accept legal advice only from a licensed legal professional with whom you have an attorney-client relationship. You should contact your lawyer in your area immediately to assist you in any of these matters. Unless you have a signed engagement letter with me, I am not your lawyer. And the presence of others in this presentation means that no communication here is covered by attorney-client privilege. All right, now that legal part is over, a little bit about you. So by a show of hands, how many of you are business owners? All right, and how many of you have done some research on trademarks? Okay, and how many of you have started a trademark application but got stuck somewhere along the way? Okay, and has anyone filed a trademark application altogether? And has anyone had a trademark application allowed or have a trademark registration? All right, that's good. It's good, just good to know where everyone stands here. Okay, let's take a step back and think about, okay, what's a trademark? How is that different from a copyright and patent? Well, there are three main types of intellectual property. First is a copyright. This is an original work of authorship. These are things like books, photographs, artwork, music, videos, podcasts. These are creative type things. They last a really long time. So generally the author's life plus 70 years. And this is the creative stuff. On the other side here, we have patents. These are for new and useful inventions. They last around 20 years. These are things like devices, methods, product design, plants. We're not going to be covering either of those today. We're going to be talking about trademarks. A trademark is an indicator to identify a particular source. Trademark can last indefinitely with continued use, and some things you can trademark are business names, logos, slogans, product names, and things like that. Okay, so a trademark is a consumer protection, and it's an indicator of quality. It identifies a source of a product or service to distinguish from other sources. So there are three terms of art in this area. There's trademark, which is a mark that's used for a product. A service mark is a mark used for a service. And trade dress is some sort of non-functional feature to identify a particular source. So a trade dress could be something like what the inside of an Apple store looks like, or the shape of a Coke bottle. Those are things that are trade dress. So what can be trademarked? Words, drawings, a store design, a scent, a sound, color. So tons of different things can be trademarked. Today, we're just going to be focused on business names, product names, and logos. So like the really simple stuff. If you're interested in trademarking a sound or a scent or something like that, you should really contact a lawyer. We're not going to be covering that today. All right, so the best way to protect a trademark is with a federal trademark registration. Once you have a federal trademark registration, you can use this awesome R in a circle. That's what that means, is that whatever mark the R in the circle is next to has been registered with the United States Patent and Trademark Office. Before you get the registration, you can use the TM symbol. So right now, all of you can put your business name and then TM after it. Let's see, so in order to qualify for federal trademark protection, your mark must be used in what's called use in commerce, so some commercial use, either interstate between two states, between the United States and some foreign country, or in DC. The mark can be in use already, or you can have some intent to use the mark in the future within 3 years. The fee for filing a trademark application is either $225 or $275 per class, and we'll get into that later. It's going to be between $1,000 and $2,000 to have a trademark attorney do the stuff for you. You may have seen things like LegalZoom or Trademark Rocket or something like that. There are these services that you pay $49 or $69 or $99 to fill out the trademark application. My view is that those things are kind of a waste of money, because as we'll see today, the application, you're literally just filling out a form. And so in order for those services to fill out the form for you, you have to provide the same exact information to them. So you're just filling out a different form. The reason the attorney is going to cost you $1,000 or $2,000 is you're not paying them to fill out the form. It doesn't take that long to fill out the form. What you're paying for is the strategy. They're going to help figure out what the best strategy is for you, which trademarks you should be registering, what the good description should be, and what classes you should file in. So that's really what you're paying for. If you want to fill out the form, don't pay someone else to just do the form. Save that $99 and buy yourself something nice. Once you have a federal trademark registration, you can enforce it nationwide. So if your business is here in Virginia, you get a trademark registration on your business name, you can prevent a business in California from using the same name for same or similar goods. Or any other US territory, Puerto Rico, Guam, places like that. A federal trademark registration may be renewed for 10-year periods indefinitely. So as long as you continue using your trademark, you can continue renewing your trademark registration. All right, so why should you file a trademark application? Well, for one, a trademark registration is an asset. So you're creating value in your company. Another reason to do it now rather than later is because marks registered for more than 5 years become incontestable. So what that means is if you have a trademark registration, you start a lawsuit against an infringer, their first response is going to be, well, your registration is not valid. And then you have to show that it is valid. But if your registration is more than 5 years old, it becomes incontestable. So that argument that the infringer is making is not going to go anywhere. Another reason to file a trademark application is it can establish value for funding or sale. So again, you're creating an asset, and it's something else that adds to the value of your company. Once you have a trademark registration, you can take domain names that include that mark away from cyber squatters. So that's sort of a nice thing to have in your arsenal. Of course, you can use the circle R symbol. And finally, you can file a lawsuit for trademark infringement. All right, step 1. We're going to start at the very beginning. You have to create an account with the USPTO. So you can go to uspto.gov, and the link is in the chat. You hover over the trademarks tab, and then you click on apply online. It's fairly straightforward, but as you'll see, the USPTO has a ton of information, and sometimes it's a little bit difficult to wade through. So I'm trying to distill down the basics of what you need to know. It'll take you, once you click on that link, it'll take you to this page, apply online, and you click on log into TEAS and TEASI page. So TEAS stands for Trademark Electronic Application System, and the I stands for international. So if you're an international company wanting to register your trademark in the US, you use TEAS-I. So you may hear me refer to the USPTO and the trademark office. It's the same thing. I'm referring to the same place, so I'll use those sort of interchangeably. Electronic filing is the easiest, fastest, and cheapest way to communicate with the trademark office. In some instances, you can still file on paper, but it has a far higher filing fee, everything's slower, and you have a greater chance of making a mistake. As we're going to see when we go through the trademark application online, if you do something wrong or you leave a box blank, it won't let you go on to the next step. So it's actually very user-friendly in that way. It'll kind of stop some mistakes in their tracks. All right, so once you click on log into TEAS, it'll take you to this page, and you click on this big green button that says set up your uspto.gov account. And then that will take you to this page. You'll click on this white button that says create a uspto.gov account. It'll take you a page where you fill out a form with the email and your name. You'll be sent an email, and there'll be a link in that email to activate your account. So you click on that link to activate your account, and it'll take you to a page where you fill out the rest of the form. You put in your password, your address, and I would highly recommend activating the two-step verification. I'm sure all of you are familiar with that, but that basically is you get a text message or an email with a code that every time you log on, you use that code. Very important here, write down the email and password in a safe place, because basically what's going to happen is you're going to spend a day or a week or however long it takes for you to do this application. And then you will wait, and in 3 months, you'll get some correspondence back from the trademark office. And then you'll have to be like, oh shoot, which email did I use? What was the password? How do I get in again? So write it down in a safe place, because if you're anything like me, you will not remember which password you used, which email you used, and then you'll be, trying all these different variations and get locked out. So don't be that person, write it down. Okay, here's where we're gonna switch to a live view of me filling out an electronic form. Really exciting, right? Okay, so I'm gonna log into my USPTO account, and let's see if I can remember my password. Okay, now I have to enter because I have my two-step authentication, and I know this is riveting content, but please bear with me. Okay, so now we're into the USPTO. This is what it looks like. And what you go to is the trademark form finder over here. And then you click on file an application. When you click on that link, this other thing will pop down, and you click on file a TEAS application. All right, so what you will see here is every single page of the application is going to have a huge amount of information on it. The USPTO provides a ton of information to individuals who are new to the trademark process, but it's going to take time and effort to sift through it all. That's why I'm holding this workshop, to cover the basics of what most small businesses will face. So if you scroll down, see again, there's a lot of information. There's links to videos, there's links to other informational pages. There's a lot of stuff going on. Okay, so after 25 minutes of inactivity, you'll be automatically kicked out. It's really important that you kind of stay active within the application until the very last page when you can save it. And we'll talk about that at the when I'll show you how to save it when we get to the end. Okay, so step 1, T's plus or T's standard. What do these mean? Okay, so T's plus is cheaper. It's $225 per class. T's standard is $50 more, so it's $275 per class. The benefits of T's plus are that it's cheaper. And the reason it's cheaper is because it really streamlines the whole process for the trademark office. I highly recommend using T's plus if possible. There are 2 things about T's plus. One, you have to file a complete application, which means you have to pay the fees at the time of filing. The second one is the goods or services have to come from a pre-existing list. You can't make up your own description. The nice thing is the list is very comprehensive. And the second link that I put in the chat, way up at the top, is a link to what that master list is. So you can go ahead and search that list and see if the goods or services, if there's anything that matches you. T standard, there's higher fees, but you don't necessarily have to pay the fees at the time of filing, and you can create your own description of goods or services. So if you have a business that does something that is completely revolutionary and nobody has ever filed a trademark application for it before, you may have to go with T standard because the description of your goods or services won't be in that master list. But again, I recommend T's plus whenever possible. It just makes it super easy because you don't have to think about whether your description is good enough for the trademark office. If it's found in the master list, it's good enough. Okay, so question 2, is an attorney filing this application? You're going to be clicking no. And again, see this advisory popped up. We recommend you review the materials on the Trademark Basics webpage. So the trademark office provides a lot of information for new trademark, people who are new to the trademark system. If you're a foreign business, you must hire a US-based attorney. But if you're based here in the US, you can do it on your own. Just something to note is everything that's in the trademark application is going to be public record. And so everyone will know that you're filing this without an attorney. You will 100% be spammed by law firms or other services who are saying, hey, I saw you file the trademark application without an attorney. I can be your attorney. And the thing is, some of these emails are going to look a lot like emails that come from the US Patent and Trademark Office. So just be careful when you get an email that references your application, because it may not be from the USPTO. So just check the address the email address it came from, and just make sure it's a uspto.gov address, so you don't go and clicking through random stuff. Okay, and then step 3, and this is optional. This is if you have already saved an application, you can upload it. So you can go to right where you started from. Just know that you can only save your application once you get to the very last page. So just make sure that if you exit, or for whatever reason you time out from 25 minutes of inactivity anytime during the application before you save it, it's gone. And it's not going to be a huge problem, but it kind of stinks to lose all the work you've done. So make sure you keep going all the way till you get to the end and then save it, and then you can think about
Phyllis, I have a quick question.
Sure.
So if while we are working on it and we're asked a question and we need to retrieve information, but it will take us time to get that information, what is the best format to save it in, and then to use this function here where we can essentially return to a file that we created? What form should we use?
You can't save it until the very end. So if there are things that that's a great question, Lisa. If there are things like, oh, I didn't know I needed that, it's going to take me time, more than 25 minutes to get it. There are ways of just sort of filling in the blanks with just garbage, essentially, placeholders, I should say, placeholders, and then proceed all the way to the end and then save it. And we'll cover how to save it later, but there's a button that says Save Application. You click it, an object file gets downloaded to your local system, and then at that point you can click on this box, click on the Browse, and then open it up. Does that answer your question?
Well, sort of. So I was expecting you to say something like, oh, well, a Word doc works well, or a Notepad would be better, or... Oh,
well, the thing is, most of the information is stuff that you will know anyway, like it's your business contact information. The two sticking points are probably going to be the description of your mark and the specimens, which is a photograph or an image of your mark in action, basically. And when we get to that section, I'll show you what you can click in order to move on past that and get to the save section. But there's really nothing in the application that should be a huge surprise to you that you'd need to write down. Like there's not a lot in the application that you're going to need to know, and there's no way of pulling in information from a Word document into this online form, other than the object file that gets downloaded once you click the Save Application button. Am I answering your question?
Yep, sorry.
Okay.
I should just
Phyllis.
Yeah.
Phyllis, this is Tina.
Hi, Tina.
Hi. I just want to piggyback off of what Lisa was saying, though. Is there a way that we can know what the questions are that we're going to be answering? And that way we can, plan for it ahead of time. So that way, if we know what we're answering, then we can build it. And then it's pretty much just a copy and paste from Word, or at least we have it where we're just literally typing it again.
Exactly. That's why we're going through this. And the thing is, if I quit right now, nothing has been submitted. The trademark office doesn't even really keep a record of what I've done. So once you have your USPTO account, you can get on here and play around, and there's really no consequence for exiting at any point before you hit submit.
Oh, I see. So your recommendation is for us to create an account and then go through to kind of get an idea of what's going to be asked. And then we can kind of exit if we need to build it and then come back.
Exactly.
Okay.
Yep. You can keep doing this all day if you want. There's no consequence. You're not paying up front. There's no record of this, really.
Okay. Thanks.
Okay. So now we're going to hit continue here. And the owner information. So this seems really straightforward, but actually there's a lot of mistakes that get made on this very first step. It's a very common mistake among people who are filing a trademark application on their own to put their name as the owner of the mark. So if we're using DCfempreneur, some people might put Lisa Shapiro here. And then they think, well, DCfempreneur is an LLC, so then they click on the LLC button. But the thing is, the owner of the mark should be the business name. It shouldn't be the owner of the business. So the owner of the mark is the business, and that's separate from the owner of the business. Don't make that mistake. So the trademark is held in the business, even if you're a single member LLC. So we're going to use DCfempreneur as our working example. And then we're going to click on it's an LLC. So once we do that, this other thing pops up and you have to fill out it's an LLC in Virginia. So there are a few reasons for why the business should be the owner of the trademark. There's some business reasons. For example, the trademark registration is an asset that can convey either with the business or sold separately from the business. So it makes sense for the business to own it rather than you as an individual to own it. And then there's also a legal reason for this, that the business is the one who has a stake in enforcing the trademark against potential infringers, whereas an individual owner generally does not. So that means if Lisa is the owner of a DCfempreneur trademark registration and she sees, oh, someone else is using DCfempreneur, they're infringing my trademark, I'm going to file a lawsuit, there's a chance that the court will say, who are you, Lisa? What stakes do you have in DCfempreneur, the trademark? You're not getting hurt at all. It's DCfempreneur LLC that's getting hurt from the infringer. So the lawsuit could be dismissed for lack of standing. So that's a legal reason why you always want to have the business be the owner of the trademark rather than you as an individual. What's really important to know is you cannot correct the owner after the application is filed. So if you accidentally put in your name as the owner of the mark instead of your business, that means that you are the owner of the mark. You can't change the application, but what you can do is you can execute something called an assignment, which basically you're transferring the rights in this mark from you yourself as an individual to the business that you own. So you can get around it, but the owner of the mark, the original owner of the mark, you can't change that in the system. You're going to have to file an assignment to do that. Okay, so then you can fill out the rest of the address. So just so you know, everything in this trademark application is going to be public record. So if at all possible, try to use a business mailing address and a business email rather than your personal email or your residence address. A PO box works. So if you don't have a business address, let's say you work from home, I would suggest getting a PO box. That way your residence is not a matter of public record. But I pulled Lisa's address from the public record from when she filed her LLC. So I'll go ahead and put that in right now. I know this is riveting content, watching someone else fill out an online form.
So I have a question. If your LLC, though, is your home mailing address, is there an issue with that? Like, shouldn't they be the same?
It doesn't matter what your LLC address is. Okay. This is for the purpose of trademark. So the trademark office doesn't look at your LLC registration and see if they match up. Is that your question?
Yes, thank you.
But just so you know, like, this is completely an aside, if you file an LLC with your home address, that's also public record. So just something else to think about if you have not already established your business entity. Okay. So you don't have to enter a phone number, and if you don't, once you click go ahead, the trademark office, the application there'll be an automatic message that pops up that says, we highly recommend you include a phone number. But again, you don't have to. And then I'm just going to put my email in there. But if Lisa was doing that, she would put her email in there. And then if you wanted to, you could add another owner, but that's optional. And then you click continue. Oh, this always happens. This box somehow becomes unchecked. There we go. Okay. So now we're on this next page, which is the mark. This is the whole reason you're doing this, right? Because you have some sort of mark you want to register as a trademark. Today, we're going to be covering word marks, which is known as standard character, or logo, which is a design. So as you scroll down, you can see right here, it says click the appropriate circle to indicate mark type. Standard character, specialized form, which means words in a special font, or a logo that's part of a design, or sound. We're not going to be covering sound today. Sorry, guys. So for standard character, basically all you do is you type in your mark into this box right here. So and then you can preview the USPTO generated image, and basically this is what's going to show up if anybody's searching the trademark database. There it is. So it's just in plain text. So as an aside here, some people like to put all caps. And in certain situations, if you put in all caps, then you could make the argument that any combination of upper and lower case is fine. So I tend to do all caps. You don't have to, but it's just sort of a stylistic choice. Okay, or you could do a special form. And here, this is like if you have a logo. Here you'd have to attach or upload an image file that shows your logo. If it has any words in it, you'd type it into this box, and then you can claim colors. And then there's also, if you could do more, you have to include a description of the mark. So for DCfempreneur, as an example, in addition to the word mark, DCfempreneur itself, Lisa also has, these are just a couple examples of the logo she has. So she's got DCfempreneur in stylized writing with color, and then there's also supporting female entrepreneurs, a slogan underneath. She also has it in this other form. So in an ideal world with unlimited resources, you would go ahead and file trademark registrations for all of these. So the word, this logo, this logo, this logo in grayscale, this logo in grayscale, maybe just DCfempreneur alone, maybe just supporting female entrepreneurs alone, you know, all these different combinations. But in reality, you have to have some sort of priority list. So for trademarks, I highly recommend always trying to get the standard character mark first, because that's going to be the strongest mark. The reason is this logo includes the words DCfempreneur. So this logo actually would fall under this registration as well, as with this one. But if you only had this logo as your registration, it would not include DCfempreneur alone. It would not include this logo because they're separate. So those are some considerations. Okay, let's go back. Okay, so I'm just, for the sake of time, I'm just going to do the standard character. And then at the bottom here, you'll see this box that says additional statement. This additional statement may or may not apply to you depending on what your mark is. So I'm going to check here so you can just see what these things are. Additional statement. The first one is disclaimer. What this means is sometimes part of a mark has to be disclaimed because it's so generic or descriptive of the goods or services that they can't be enforced against someone else. So for example, the chocolate company, See's Candies. See's Candies has a trademark registration for the word See's Candies, the mark See's Candies. The word candies is disclaimed. which means that C's Candies cannot enforce their registration against other people who are using candies alone in their mark. So if I had a business called Phyllis's Candies, C's Candies could not come after me. But if I had a mark that was Phyllis's C's Candies, then they could, because they can only enforce C's Candies as a whole. What's important to know is, do not disclaim anything until the trademark office tells you you have to. Don't try to get ahead of that and think, okay, I just want to get this through the first time. I'm just going to make everything super easy for the examiner. Don't do that, because you don't know if the examiner is even going to make you disclaim it. You can anticipate maybe they will, and just prepare yourself for that, but don't disclaim anything in your initial filing, even if you think you should, because you may be giving up some rights that you won't have to. The next one is active prior registrations. So for example, if Lisa had already gotten the standard character mark DCfempreneur, and now she's ready to file an application for one of the logos, then she would put the US registration number for the word DCfempreneur here. Translation means if your mark has a non-English word in it, you can put the translation here. It just makes things easier for the examiner. Same thing with transliteration. And this means if there's, if in your logo, this is for drawing, so if in your logo there's some sort of symbol, then you would put what it means here to just move things along with the trademark office. Names, portraits, or signatures of individuals. So if part of your mark includes the name of a living individual or their image, then you need to get their consent. So sometimes that person is you, and then it's easy to give your consent. Sometimes that person is someone else, and then you'll have to get their consent. Or if there's a name or a portrait or signature in your mark that doesn't refer to any particular living individual, like King Arthur Flower. Well, King Arthur is not alive anymore, so then you would just click this box. So there's just a bunch of different things. Again, it's going to really, whether you need this really depends on what your mark is. So for right now, I'm going to uncheck that box and then push continue. Okay, goods and services. This is really the most difficult part of the entire application, and it's the part where a lot of mistakes can happen. But I'll try to help you, give you some tips for best practices. So remember, for Ts Plus, you have to choose from the list of existing goods or services. And so clicking on this button here, add goods or services, will take me to a database that, a searchable database of that list. Okay, so search for. Okay, so DCfempreneur, let's say they do podcasting and networking. So I'm going to type in podcast here and enter. And you see there are 8 entries in the database that have podcasts. So there's production of podcasts, transmission of podcasts, telecommunication services, namely transmission of podcasts. Okay, so there's several different options here. And maybe Lisa's saying, well, I do have a downloadable podcast, class 9, and I'm also producing podcasts, and I'm also, entertainment services. I'm providing video podcasts, and I'm providing podcasts in the field of, and then indicate that. But now we're looking at 3 or 4 different classes. And remember, each class is $225. So if you're really on a budget, I would recommend limiting the number of classes. So if you want to cover podcasts, just pick one of those. And in this case, I would probably pick this one, International Class 9, which is the podcast itself. These other things are services, like providing the podcast, transmitting the podcast, producing the podcast. But in this case, I would pick the actual podcast itself. So I'm going to check this box and then click on Insert Checked Entries. So if you notice, this right here, the one I clicked says downloadable podcast in the field of, and then these curly brackets say indicate field or subject matter. So that means that I have to indicate the field or subject matter. So I'm going to put in entrepreneurship and then insert checked entries here. Okay, so it takes me to the next page, and see, it's the thing that I indicated is right here. I want to add also business networking. So I'm going to click on add goods or services, and it'll take me back to this one. And then I'll put in business networking. Okay, so now there are 21 different services here. What I like to do is sort by class. And so you click on this double-headed arrow right here. And you see that class 9, there's software allowing users to conduct electronic businesses. You know, that's not it. So I'm just going to scroll down, and up here, there's just good old business networking. So here's something, 2 tips for you. One, you can always amend the goods or services description later on to be more specific. So you can always narrow down your description later after you file the application. But after you file the application, you cannot amend it to be more broad. So if at first you chose this one, which is business networking of peer-to-peer learning groups in high net worth individuals, well, that's really specific. And later on, you might want to say, well, it's not just high net worth individuals. I'm also serving moderate net worth individuals. Well, you can't do that because that would broaden the scope of your description. So what I always recommend is go vague first with your initial application. And sometimes the examiner will say, no, this is way too vague. You need to be a lot more specific. And then you can add in some detail. But remember, you can never take details out and make things more general. So it's better to start an application with a more vague description rather than one that is really specific. The other important thing is when you file this application, one of the boxes you're going to check when you sign it is basically that everything you're submitting is true upon threat of perjury, which could mean fine or imprisonment. It's a pretty high standard, and I don't know of anyone who's been imprisoned for getting something wrong, but I do know of people who they put goods and services in their description, and it turns out that they never really use their mark on those goods or services, and then you're actually committing fraud on the trademark office, and your entire trademark registration will be canceled. So you have to declare the use on all of the goods and services that are in your description for the lifetime of your trademark registration. So remember, that's 10 years. So choose your goods and services wisely. I always recommend what you should put in your initial application is the core function of your business. So there's a lot of people who have, especially when they're starting out, they're not really sure where their business is going. So it could be like, okay, I'm going to start with podcasting, but I really do want to have a book tour and a speaker series and a video podcast, a video blog. Like, they just have all these ideas. That's awesome. However, you don't know if those things will materialize over the next 10 years. And if they don't materialize and they're still on your application, you're committing fraud. So only put the things on your application that you're actually going to be doing. It shouldn't be pipe dream type stuff, but you should also include everything that you're actually going to do or have a very high likelihood of doing in the next 10 years. Does that make sense? Okay. So I'm going to click on business networking and then insert checked entries. So again, it's going to take me to this page. So I've got my downloadable podcast in the field of entrepreneurship, and then I have business networking. And see, there are two different classes. They're class 9 and class 35. You can insert more than one description in the same class. So I could have 2 different class 9s, 2 different class 35s. You can basically have anything you want in this. But remember, every different class here is going to cost $225. So if I had 2 35s, it would cost $225 for both of them. But because I have class 9 and class 35, they're separate. So the total would be $450. And now this is where it gets a little bit trickier. Is everyone still with me here?
Yeah, this is really helpful.
Okay, so you can ignore this half over here, section 44. Those are for foreign applicants. It's probably not anyone on this call right now. So your choices are section 1A or section 1B. So what's the difference? Okay, section 1A means you're actually using the mark in commerce right now at the time of filing. So that means for a good, you've actually made a sale or you've somehow transported your goods. If it's a service, you've actually performed the service. Mere advertising is not enough. So you can't just say, well, I posted a flyer on my Facebook group for a workshop that I'm giving next week. That you're using your mark, but you're not using your mark in commerce. So in that case, it would be 1B until you actually give your workshop, and then it would become a 1A. So for 1B, this is sort of a placeholder, and it's saying, look, I'm going to be using it. Let's get all the paperwork out of the way, and when I'm actually used it, I'll submit all the stuff that says I'm using it. And you have basically 3 years to start using it. It's going to cost you a lot of money in extension fees, but you can extend up to 3 years. 1B is generally for large businesses that are going to sink a lot of money into market research and marketing, and they want to make sure that the mark they're planning to use is cleared. You can have both 1A and 1B in the same application. So for example, let's say Lisa is doing business networking now, that would be 1A, and in the future she wants to do a podcast, then the downloadable podcast would be 1B. And I'll show you how to do that. Okay.
Phyllis, can I ask a quick question about
sure.
that? So I've already had sales, so I would have a 1A, but if I wanted to start using my logo, let's say, on like t-shirts or mugs or journals or something like that, but I haven't done that yet, would that be considered a 1B?
Yes.
Okay.
Yeah. So because I don't know what your business is, but the 1A would be whatever goods or services you're currently doing. So
Yes.
that might be a different class than the t-shirts or mugs.
Got it.
Like for example, t-shirts and sweatshirts are the same class. So let's say you've already got your t-shirts, your logo on your t-shirts.
Yep.
Then that would be a 1A for the t-shirts and then a 1B for the sweatshirts, even though they're in the same class. So that's possible as well.
Okay.
So think about that when you're doing this part, because it would be apparel, namely t-shirts, and then you'd have to do another field for apparel, namely sweatshirts, because you have to split them into what you're using it on already and what you're going to use in the future.
Okay, quick question, Phyllis.
Got it.
Sure.
So, okay, so let's just assume that I'm not applying for my podcast class 009. I'm only going to start with 035 with the business networking. So does that mean that if somebody uses the name DCfempreneur for a business networking blank, that would be an infringement, but not if they started a DCfempreneur podcast, because I do not have the trademark on that podcast?
Yes. That's
so
exactly
somebody
right.
could take my logo and my business and put it on t-shirts and mugs, and I would have no standing.
That's right.
Holy cow.
Mm-hmm.
I don't like that.
Right?
But don't get
Right?
Holy business.
Yeah.
None of y'all do that, okay?
Yeah, but you know what? Don't go too crazy about, well, I do have water bottles and I do have tote bags, and do I need it? Don't worry about that, because especially if you're on a limited budget, you really want to protect the core of your business, which is business networking. So if someone else is doing the legwork and making tote bags and selling them with your logo on them, hey, you're missing out on the sales of that tote bag, but all of their customers are now advertising for you. So, you can see the upside of that.
Oh, I like that idea.
At least there is an upside.
Okay, does anybody have any questions so far?
I'm sorry, did I miss that?
Does anybody else have some questions so far about the core function of your business, or anything that we've done so far?
I do have just one question, but it was something that was said early on, but
Okay.
I'll ask it now. You had mentioned that we all could use TM in our name.
Yep.
Can you help me understand why again? Why can we use it right now?
Okay. TM is just an indicator to the rest of the world that you're using this name as a trademark, which means an indicator of source. So sort of, you can think about it as if you have a house and it's on a piece of land, you own that land. But once you put a fence around your land, that's an indicator to other people that, hey, this is mine, not yours. I'm protecting this area right now. So TM, it's what we call notice to other people that if they start using it, they can't say, oh, I didn't know you were using it as a trademark, because you had TM on there. And so it's really clear to everybody that you are using it.
Well, can you use it before you file for the trademark? I thought the TM was an indication that a trademark application was already filed.
No,
No.
you don't need to have an application on file. It just, you can have TM without doing anything. So in that sense, TM is not really all that meaningful, but neither is like a sign on your front door that says private property. Well, of course it's private property, but some people really like making it clear to everybody, like, hey, this is private property now.
Okay.
And where do you put TM? Do you put it on your logo?
You can put it on your logo. One thing to know though is if you're using an image, when the image that you upload to your trademark application for your logo, it should not have TM on it. So right now you can use TM on your logo if you want to, but just remember when you put it on whatever version you put onto the application should not include TM.
Okay.
And if you do include TM, the trademark office will say, provide another image because you can't use TM. Right, so it's not the end of the world if you do it. They'll tell you how to fix it, but it's still something that you have to fix.
Thank you, Phyllis.
Okay, so let's say that we're going to do business networking, and we'll say that section 1A, we're actually using it in commerce now. So that means you have to attach a specimen. A specimen is an image that shows use of the mark on the product or service. So for an actual product, it can be a label that's on the product. If you have a hang tag, which is, when you get a new article of clothing, there's that piece of cardboard with a logo on it and maybe a size and maybe a price that's hanging by one of those strands of plastic that you cut off before you put on. That's called a hang tag. So you can show an image of the article of clothing with the hang tag attached. You can't just say, oh, here's a picture of a hang tag that I'm going to put on the shirt that I'm selling. It has to be actually attached to the good. Same thing with label. You can't just submit like a sheet of stickers and say, these are the labels that I'm using on my products. It has to be a picture of the product with the label on it that shows the mark. Another thing that's important to know is if you, let's say we're doing DCfempreneur, the word, the standard character mark, you can submit a specimen that has DCfempreneur as part of the logo. Because remember, what they're really looking for is the words in action. So even though you're submitting the application just saying plain text, the specimen can be the text in fancy writing or part of a logo. That works too. Other specimens you can use are a brochure or a screenshot of the mark along with a picture of the goods or a description of the services. So for something like if you're hosting a workshop, it's really difficult to attach a label to a workshop because what does a workshop look like? But if you have a flyer that says your mark, and then I'll be hosting a workshop for, whatever on this day and all of that, if there's a description of your services, then that counts. So for screenshots, this is really a really new rule. The screenshot must include the full URL and the date of the screenshot. So if I was to take a screenshot of this, it would have to include this stuff up top. And then also the date that the screenshot was taken. So that's a pretty recent rule change. And then if you have a product shipped in boxes, you can no longer send an image of a cardboard box with your mark on it. Because that could be anything or an empty box. So if that's how your product is generally shipped, you need to have the box with the mark and also either a picture of the goods inside or description of the goods inside that's on the packaging. And then here you have a specimen, so we might include like a screenshot of DCfempreneur and what it is. And then in the description, you could say a screenshot of a website describing DCfempreneur services as for business networking. First use of mark anywhere. So this is where you could do your advertisement, the first time you advertised your workshop. And then the date of the first use in commerce is the date that you actually did your workshop. Does that make sense? So the first use of mark anywhere is going to be earlier or the same time as the first use of mark in commerce. Does that make sense?
Phyllis,
Okay.
could the first date or first use of mark anywhere, could that also just be when you went live with your website?
Exactly.
Okay.
Yep.
And you were asking that, Tina. I was thinking that too. Either that or like
Business cards.
Yeah, like when you file for your LLC or something like that.
Exactly.
Okay.
Yep. And remember, in commerce, it needs to be either interstate, which means crossing a state line in some point, or crossing US foreign commerce, another country, or within DC. In this area, it's really easy to get to the interstate to reach that hurdle because we're so close to Maryland, West Virginia, DC, and the chances of you having customers or clients in other states are very, very high. But if you're in the middle of, let's say, Hawaii and you do a pool cleaning service, that would be a pretty difficult standard to meet.
So I'm sorry, Phyllis, so are you saying it doesn't apply to intrastate? Like if I'm in Virginia and I made my sales in Virginia, that doesn't count?
No.
Okay, hold on.
But you could get around it. So for example, let's say you have a restaurant and people are coming to you in Virginia to eat in your restaurant. It does count as interstate commerce if people from other states could come to your restaurant. So you don't have to prove that there was someone from DC who came to your restaurant. You just have to, it just has to be reasonable enough that people from other states could come to your restaurant. So again, in this area, it's fairly easy to get over that. And again, you don't have to actually, I mean, unless you're sued, you're never going to have to prove that you've actually had interstate sales. But it's just something to think about.
Okay.
So if the chances of you having an interstate sale are very high, but you haven't actually had an interstate sale yet, that still counts.
Okay.
So that's 1A. So what you do is you attach the specimen, put in the description, the date of first use anywhere, and the date of first use in commerce. And then you push this button that says assign filing basis. I'm not going to do that. So I'm going to say remove this 1A. And then I'm just going to go to 1B for both of these. Okay, so when you have 1B, what's important to know about 1B, intent to use, which means you aren't using it yet. This requires an additional filing once you do start using it in commerce. And that filing is basically the things that we've already covered for 1A. So it's a specimen, the date of first use anywhere, and the date of first use in commerce. And this filing has a fee attached to it. So it's $100-something to file that statement. So if you're really tight on your budget, the 1B application is going to be more expensive overall than the 1A. But again, if $100-something is not a huge investment for you, but you just want to get this application off your plate as soon as possible, go ahead and do the 1B, and then just realize you have to do something later to follow up. So that's this. You check that it says, I understand that 1B requires that you do have to use it, and you have to include a specimen and a fee. So I'm going to assign this filing basis here. Option 1B. Okay, click this box and then assign filing basis. All right, so I've got both filing bases assigned over here, and so now I can continue. All right, the correspondence information. This is generally for attorneys. That's what this docket reference number is. Usually we have an internal number, reference number we use to for different clients and different applications. But for you, what could be really helpful is this email address. So what you can put in here is your business partner, so you're both in the loop. You can put in your administrative assistant, so that person's is in the loop, or some people have a dedicated email address for administrative type stuff. So it doesn't get completely lost in the shuffle. You could put that email address in there. So it's just a way of adding other points of contact here. But again, this is optional. Okay, so now it's calculated the fees for us. So we have two classes. We have class 9 and class 35. Each one is $225, so the total fee due is $450. Then you have to sign it. So I would recommend signing directly. These things, I don't know, unless, I mean, the person who can sign is either an owner or an officer of the business. So if you're filling this out, it's probably going to be you, and you'd be able to sign directly. For example, when I'm doing it, I can sign as an attorney, so I can sign directly. I don't need to give it to my client to sign and then give it back to me. So most people just sign directly here. Then you click these 4 boxes, and it's basically just you're attesting to all these things that are in the boxes. And then your signature, you just put your name between forward slashes. like that. The date will actually auto-populate, and then you type in your name here, which is a little bit silly because it's literally what's above, just without the slashes. And then the position. So you can either be the owner of your business. If it's an LLC, you'd be the principal. I'm an attorney, so I would write attorney of record. So you can write here, I'll pretend I'm the principal of DCfempreneur, and then you can put in your phone number.
Does the name need to be in last, first, middle?
Oh, you're right. Thank you, Adam.
No problem.
Okay. Okay, and then you can add, if you want someone else to sign, you can also add a signatory on it. Again, that's optional. And then you can click the validate button. All right, so you finally made it to the end of the application. Here's where you can review everything you've done. So there's input, mark, XML file, and text form. So I usually check these two. So I can click on input, and it'll give me a summary of everything in the application. So yes, it's standard characters. Yes, we're using the USPTO generated image. Here's what the mark is. The mark statement, remember, we didn't put this in here, but if you check the standard characters, this will auto-populate. Here's the owner of the mark. Make sure the mailing address is correct. Important, make sure your email is correct and your phone number, because sometimes the examiner will call you. If there's a really easy problem to fix, they'll call you and make sure, like, hey, can we do this? And if you say yes, then they'll issue something in writing with the thing you already agreed to. It just speeds things along. Just make sure everything's done here. And then you can click back. Oh, you can also save it as a PDF. So for example, if you want to make sure, get a second set of eyes on it or give it to your business partner, you can, I don't know if you saw here at the bottom, here it says you can save it as a PDF. So then you can email it to somebody else to take a look at. You can click on mark, and this will show you exactly what it's going to look like. Okay, and then way down at the bottom here, see there's a lot of information. So if you have a question, it's probably going to be, the answer will be in here somewhere. It just takes some time to figure it out. Okay, so here's the Save Form button. So when I click the Save Form button, it'll say, what do you want to do with this? I can save it. It's an object file, so teas.bas.obj, and I just save it, and then I can see it in my folder. There it is. Okay, and at that point, when you can exit out, it'll be saved, and then when you go back into your original, log into My USPTO, go to File a Trademark Application, you get to the first page, and you can click on that box, browse, and then pull up that object file, and then all the work that you've already done will be there. Here you can click Pay Submit. Remember, you can only submit one time, and once you submit, there are certain things you can't change. Remember, you can't change the owner. You can only change the description to make it more narrow. You can't change the description to make it broader or expand it. So just, maybe sleep on it before you submit it, just to make sure that's exactly what you want to do. And once you click Pay Submit, you can pay using a credit card. You can see right here, it says click on the Pay Submit button below to access a site where you select one of 3 possible payment methods. you're probably just going to use a credit card. The other two are for people who have accounts with the USPTO, and those are, you know, people like me who do a lot with the PTO, and so we need to have, it's helpful for us to have an account with them, but you can just pay with a credit card and it's very easy. Okay, so you've submitted your application, congratulations. So what's next? And so we're gonna go back to these slides. And I will send out, or maybe Lisa will send out a PDF because all of this is in there. What's next? Okay, you'll receive an email acknowledgement of your submission within minutes of filing. Everything's automatic. So at that point, you will have an application number, and that will be your reference number. So every time you correspond with the trademark office, you'll use that reference number. In about 3 months, the trademark office will issue a letter by email, and this is called an office action. So what I tend to do is once I file an application, I will put in a calendar reminder for a week later just to make sure that the application was accepted, because sometimes things do come up. And then 3 months later, I'll put a reminder to look for an office action. And it's usually right around the 3-month mark. So once you get the office action, you have 6 months to respond to the office action, or the application will go abandoned. So 6 months is both a blessing and a curse. It's a nice long time. You have a ton of time to figure out what you need to do, but it's also enough time for you to forget to do it. So once you get that office action, what I like to do is put monthly reminders of like, hey, you've got 5 months left, you have 4 months left, you have 3 months left, just so nothing falls through the cracks. Because once we, you know, as you know, when you own a business or you have a small business, you've got so many things going on you need to take care of, and responding to a trademark office action is probably really low on your priority list. So just make sure you have some way of keeping track of time. So the responses to the office action use the same TEAS online platform. Everything's done electronically. And just like the application, I'm not going to say user-friendly, but there's a lot of information. All the information you need is going to be there. It's just going to take it might take a little bit of work on your part to figure out the actual information that you need. So here are some possible office action scenarios. Best case scenario, the trademark office approves your application. What comes next? You don't need to do anything. Your mark is published for opposition. This means that a third party can file a formal objection called a notice of opposition to your mark with the trademark office within 30 days of publication. So they only have 30 days to do that. If no oppositions are filed within 30 days, your mark proceeds to the trademark register and you're done. You've got your registration, you can use the R in the circle. And then once you've got the registration, in 5 years, you have to file a statement of use saying, yep, I'm still using it. And then 5 years after that, in 10 years, it's up for renewal. And at that point, you can say, yep, I'm still using it, pay your fee, and then you get another 10 years. So that's sort of the timeline. More often, the trademark office refuses your application. There are many possible reasons for refusal. You must respond to all of them. You can't just say, okay, the examiner gave me three grounds of refusal. I'm just going to pretend the third one doesn't exist because I'm not sure what's going on. Just respond to all of them because otherwise it's incomplete. If you don't really know what's going on, just read the office action carefully. There is a lot of information in there. It's good information, but it is a lot of information. And for the most part, the trademark office will tell you exactly what you need to do. And if you do exactly what the examiner suggests you do, the chances of you getting approved are very high. Remember, the examiner is on your side. It's not some sort of litigation and fight between you and the examiner. The examiner is not the gatekeeper. The examiner is your guide in helping you get a good trademark. So in that sense, you know, do what the examiner is telling you to do and things will be fine. So sometimes the grounds of refusal are really easy fix, and sometimes sometimes you're going to want to have an attorney come in because legal arguments are necessary. So once that office action comes in, I'd be happy to look at it for you and just let you know, like, hey, look, it's telling you do this, this, and that. That's super easy to do. Just log on to Tees and get that done. I'm happy to do that for free. Because I think that, it's really daunting, but it is doable for a small business owner. You're smart enough to run your own business. You're smart enough to do this. Let's see. And finally, if you need help, again, the Trademark Office provides a ton of information. It's an overwhelming amount of information for you to sift through. There are videos, there are informational pages, there are presentations. There's a ton of information for you to do this on your own. The other resource I recommend, highly, highly recommend, the Trademark Office customer service. I mean, whoever raves about customer service, but I rave about the Trademark Office customer service. They're incredible. I love them. You call them up, they're super nice, they're very knowledgeable, and they'll help you figure things out. They do not give legal advice, but all the people there are very, very familiar with T's and what forms you need. So if you're saying, oh, I need to amend the description of my mark, I'm not sure what form to use, they will tell you exactly what form to use and tell you how to get there, from the T's log on. They're super, super helpful. So if you're at all confused, I highly recommend calling this number and just getting some help from an actual person. So that's all the prepared remarks I have. Let's open it up to any questions you may have.
Hey, Phyllis, that was really great. Thanks so much for that. Can you share with us what are your top 3 most common mistakes that you business owners make that may bring a denial that we could maybe be on the lookout for that you didn't address filling out the application?
So for sure, the ownership. So putting your name as the owner, but then LLC as the business type. I see that so often because as a business owner, you fill out so many forms and you're like, I'm the owner of my business. I'm going to put my name there. But remember, the owner of your business is different from the owner of the trademark. So that's one thing that's very easy to avoid. Another thing is when you're doing if you're doing an intent to use application and just thinking, oh yeah, I'm going to want mugs and t-shirts and a podcast and a book and all of these things, and trying to put a ton of different classes in there, and then you're like, oh my gosh, these fees are like $4,000. Just trying to do too much, thinking this is your one and only chance to do it. Each class is $225, which means, and that the minimum is $225. So that means that you can literally have one application for every class, and it's not going to cost you any more money. It's going to be more of a headache to keep track of everything, but you don't try to cram everything into the same application. If you just want to start out, just do one class, just the core business function. Just do that, and then once you're familiar with that, then you can say like, okay, yeah, now I'm ready to expand into a speaker series. So then you can file another application with the speaker series, or you can even add that onto this application if the application has not registered yet. So don't try to cram everything into one application to begin with, because the fees are going to be astronomically high. And also, now you're on the hook for showing use on all of those things. Another thing is that I see a lot is people will get a refusal and they won't read through it. They'll just say, oh, my application was rejected. All right. And then they just sort of don't respond at all. But I've seen so many office actions that's a refusal, but it's like, it's refused on the grounds that your specimen is too blurry. Please provide a picture with better clarity. It's like literally all you need to do is put another picture in, right? It's not, you don't need legal arguments. That's all you needed to do. Or the office action might say, you must disclaim candies in C's Candies. Well, that's really easy, because all you have to do is you have to click the link and then type in candies in the box and then click submit. It's not costing you anything. But if you don't read what the office action says, you may miss out because you just think, oh, I was rejected. That's the end. So definitely read what comes. And again, it's a lot of information. It's really dense, but generally the trademark office is trying to work with you, and generally they'll tell you what you need to do. Thanks for your question. Are there any other questions, Tina?
Phyllis, I do not have a question, but I just want to thank you and thank Lisa. I know that some people may not like seeing you go through the website, but I'm one of those visual people where it was so comforting to see, like, this is what you click and this is what you do, because each one of those is like a landmark in my brain. And when I go through it, I'll be like, oh yes, I remember her clicking here and I remember her telling me this. Right? So for me, it was super educational, super valuable. Can't thank you guys enough.
Yay. Well, thank you. Thanks.
Very, very helpful. Thank you very much. Yeah.
You're welcome.
You made this very daunting task manageable. So
it actually makes you feel like you could do it, right? Like,
yeah. Thank you. I have another call I have to get on, so I'm gonna hop off, but thank you.